Good evening, everybody who's joining us. Thank you for attending our workshop, Know Your Rights, Navigating NYC's Impartial Hearing System. The workshop will be led by Steve Alizio and Justin Shane from the Law Office of Steve Alizio. Once again, welcome, and I'll hand it off to Steve Alizio now. Welcome.
Thank you, Robert, and thank you to Include NYC generally for inviting us to do this very meaningful presentation. I'm just going to do a quick little introduction to who we are and what you're going to be hearing tonight, and then I'm going to pass it along to Justin to get started on some more of the substantive aspects of the presentation. So Justin and I are both special education attorneys in New York City. We do focus our practice exclusively in New York City right now. So the predominant law that we operate under is called the Individuals with Disabilities Education Act, the IDEA, which Justin will be discussing further in a few minutes. And it's a federal law, which means that it applies throughout the entire United States, not just in New York City, not just in New York State, but for all states. That being said, the way that the process actually is done can vary from place to place. And so we are obviously focusing on New York City as that's our area of practice, and that's what we understand our viewers are mostly concerned with. So Justin and I were both before becoming attorneys, before I became an attorney, I was a public school teacher out on Long Island in New York State. Justin actually had practiced different areas of law previously, and then also became a teacher in New York City. So we do have that background as well. As far as what we're going to be doing today, I'm going to pass it off to Justin in a few minutes. He's going to talk about the IDEA generally, the basics of that law, and also kind of briefly mention some other laws that are relevant and you should be aware of. Then I'm going to take it back over to talk about the impartial hearing process itself. What happens when you're unhappy with what's being offered to your children and what to do there. And then Justin's going to talk about the different forms of relief after the impartial hearing process gets started. He's going to talk about the independent educational evaluations as one form of relief. I'm going to talk about what's called pendency, or the stay put provision of the law, as another form of relief. Justin's then going to talk about how to get private schools funded for students with disabilities, specifically schools that are designed for students with disabilities. And then I'm going to talk about what's called compensatory services, which is pretty broad, and I'll explain that more. For the most part, it's making up for past deprivations of what's called a free appropriate public education. And then we're going to try and leave room for questions, hopefully about 15, 20 minutes of questions. So, feel free to ask the questions right now if you'd like. We're not going to be answering them yet. We're going to try and answer them later on. I'll also say, when you do ask your questions, try and keep them very generic. Do not give any identifying information about you or your child. If you're a parent, please just try and keep it general. And we're not going to be able to answer everybody's questions immediately. Okay, that's just not going to happen. There's a lot of people participating. Robert's going to be putting, if he hasn't already, both of our email addresses in the chat box. And with that, you're going to be able to contact us later on, and we can schedule a time to talk if you'd like to discuss something specific. Okay, and what else I want to say very briefly is, I think Robert's also going to be putting in a resources page of our website that we welcome you to take a look at. We have some good resources there, I think, some past presentations and some other resources. We also have a low-income resource page within that resource page. And so a lot of times people say, well, I can't afford an attorney. Well, you might not have to afford an attorney. There are many organizations that that provide free legal services to low-income New Yorkers. And then there's other attorneys and law firms such as ours where we provide services on a sliding scale, flat fee basis. In some cases, we can take some cases at no upfront cost to the client. So those are things to consider. And then the last thing before turning it over to Justin is just that I want to make clear that nothing we're providing today is meant to be legal advice, right? We're talking in generalities, and that is just kind of what we're doing. So without anything further, Justin, why don't you take it away and discuss the IDEA?
All right. Well, thank you, Steve. As Steve said, the purpose of this presentation is really to discuss the impartial hearing system. However, I think it's helpful to provide some context by providing just some briefly on the basics of the IDEA. So obtaining special education services for a student K through 12 starts with an initial referral, and that can be either done through a parent requesting special education services or a teacher or administrator from this child's school referring a child for special education services. From there, the evaluation process begins. Now, I think an important point that parents need to be aware of is that the school district has what's called a child find obligation, which is a duty to identify, locate, and evaluate any children that need special education services. This is regardless of whether the student is in a public school within the district or a private or religious school within the district. The child find duty applies regardless. So something to keep in mind as you're thinking about your rights under the IDEA. The evaluation process itself, after the referral, the school district has 60 days from the date it receives consent from the parents to conduct the evaluations. From there, once the evaluations are complete, the school district holds what's called an IEP meeting, or a meeting to create an individualized education plan. At that initial meeting, the school district will first determine if the child is a student with a disability under the law and thus entitled to special education services. If they do make that determination, they will then create a special education plan or IEP for the student. A child with a disability under the IDEA is entitled to a free, appropriate public education, or FAPE, in the least restrictive environment. We're not going to go into super in detail into the requirements in creating an IEP, but I will say that there are both substantive and procedural requirements that the school district is required to follow in creating an IEP for a student. Procedural requirements include things like who needs to be present at the IEP meeting, parents' role, allowing the parents to participate meaningfully in the meeting. Substantively, the program offered by the IEP team must be, under the law, reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So this is something more than de minimis progress. Courts have held that pretty consistently, but it's also not the student isn't entitled to sort of the Rolls Royce of special education programs. It's somewhere in the middle, reasonably thought out and calculated to allow that student to make progress. From there, the school district is also in charge of implementing the IEP. So the IEP will set forth numerous mandates for the child special education program. And the school district then has to actually implement those, such as putting the child in the correct classroom, providing the student with the related services that are mandated on the IEP. If it requires a different school placement, offering the student a seat in an appropriate school. So again, the due process doesn't end with the creation of the IEP. You also need to keep in mind, okay, is the school actually implementing what's on the IEP to the letter? Because that could also eventually result in claims against the school district. Two other things just briefly. Students in private schools or religious schools where the parent is paying the tuition, they're called parentally placed students. They are also entitled to special education services under the law. They receive what's called an Individualized Education Services Plan, or an IESP. And similarly, that IESP will mandate special education and related services that the DOE, or the school district, must fund for the student in that private school. And finally, just one other thing that you may hear sort of thrown about is a 504 plan. That's referring to Section 504 of the Rehabilitation Act, which is a federal civil rights act. It is not just for students K through 12. It applies much more broadly than that. But there are such things as a 504 plan that students may receive, and that often involves more things like accommodations and things related to the students' access to certain facilities within the school. And with that, I will turn things back over to Steve, who's going to talk about the impartial hearing process itself.
Great, thanks, Justin. And yes, as Justin suggested, we could probably spend all night on any individual subsection of what we're discussing. That there's a lot to talk about. But I'm going to talk now about just the impartial hearing process itself. What is that process? What does that look like? Well, the idea is, if you're not happy, for instance, with the individualized educational program that has been recommended by the Department of Education, you can do something about it. The first thing to do, in our opinion, is to try and resolve it with the school if you can, right? I mean, I'm a lawyer. I help families sue the Department of Education, but I would prefer not to have as much business as we do sometimes. It would be ideal if you can work things out with the school on your own. So, you should always try that. Try and be cooperative, see if that can happen. There's also the possibility of seeking mediation. Mediation is not something that we typically do as much. That's something that you can reach out to include NYC. I know they do presentations on that, and can help you with that process if you're interested in that. But what we're going to focus on is the impartial hearing process. So if you can't come to an agreement with the Department of Education and you're unable to resolve your kind of differences of what's going on, then you can seek an impartial hearing. You do that by filing what's called an impartial hearing request, also known as a due process complaint. And you basically lay out what your claims are, right? Your claims could be that, the Department of Education created an IEP that was not reasonably calculated to confer educational benefit on my child. Why wasn't it reasonably calculated? You might say, well, there wasn't appropriate evaluative information included. They didn't allow me to meaningfully participate. They didn't care what I had to say. Whatever the case may be, there could be those types of claims. There could be claims that, you had an IEP in place, but they weren't meeting the mandates of the IEP, right? You're supposed to be in an ICT classroom, but they didn't have one. So they put your child in a different type of classroom. Or you're supposed to get speech therapy and you didn't get speech therapy. Like, these are the types of things you would put in a due process complaint. You would explain all that. And then you'd have something called a proposed resolution section at the end, where you would say, and now this is what I want an impartial hearing officer to do to remedy these allegations that I've made, right? So that's basically what the gist is of filing for an impartial hearing request. Now, what do you expect once you file the impartial hearing request? Frankly, this is in flux what to expect. Like, we're constantly having that. The law says one thing, and in New York City, just as a matter of fact, the impartial hearing system hasn't been able to keep up with the amount of due process complaints that have been submitted. So there's been tremendous hearing delays. People are aware of that. There's a class action lawsuit that gets into that. We're not going to discuss it, but that exists. There's delays in getting impartial hearing officers assigned. They've been making strides at trying to reduce that backlog. People may have heard about that. There's also something people are going to maybe know about. It's called OATH, the Office of Administrative Trials and Hearings. There's a possibility of this system being kind of switched over to this OATH system. So things might change. It's not clear whether or not that's going to actually happen. There's litigation and legislation involved with it. I'm not getting into that right now, but I do want to bring it up that this is in flux to some degree, what to expect exactly. But the basic elements will be in place, which is you file a due process complaint and there's going to be a timeline. There's a resolution period. Within a couple of weeks of filing your due process complaint, the school district is supposed to reach out to the parent and have a resolution session, a meeting in which you try and resolve the issues that are brought up in the due process complaint. I will say that in New York City, it's very unusual for claims to be resolved at least fully through the resolution meeting process. Things like, it's unheard of for me that like private school tuition, I don't think I've ever heard of that being resolved through the resolution session. There might be some compensatory claims or evaluation claims that could get resolved. It's possible, but that's what the resolution period is for. If you can't resolve everything through the resolution meeting, then you proceed with the hearing. And what does the hearing look like? Well, as of right now, it's virtual. It used to be in person. Maybe one day it'll go back to in person. The beginning of the pandemic, it was completely over the telephone. Now it's starting to go into a Zoom type format, not exactly Zoom, but that type of format where there's video. And who's present? Well, there's an impartial hearing officer that's present. There is a representative from the Department of Education. It could be an attorney or some other representative who's going to make the case for the Department of Education. There's you, obviously, as the parent. And then if you have an advocate or attorney, that person would be present as well. And then the last person that's present throughout would be this court reporter who would basically be kind of determining, making sure that you're on the record or off the record. It will be transcribed afterwards. There's a transcription of what happens during the hearing. Okay, so that's basically how that works. There are witnesses that can get called. When the witnesses are called, they are, other than the parent, they're not going to be present until they're called, right? And that's what happens. This is not like My Cousin Vinny. It's a great movie, but this is not what it looks like, okay? It's not as formal of a court type proceeding as like state or federal court either. Not that My Cousin Vinny is not accurate for that either, but this is, you know, a more informal sort of sit around the table and discuss what's going on type of thing. So that's what it looks like. After a certain period of time, you'll get a decision. It's supposed to be within 90 days of submitting your due process complaint, but that's not necessarily been the case lately. Once you get a decision, there's an ability to appeal the decision. Either you can appeal it or the district can appeal it. Within 25 days, you're supposed to put in your notice of any intent to appeal, and then within 40 days, the appeal must be completed. You can also cross appeal. If one party appeals, the other can cross appeal different aspects of it. I'm not going to go into the appellate process any further, other than just to say it's an appeal to the Office of State Review at first. In New York State, it's a two-tier administrative system. Not all states are like that, but it is in New York. And so we appeal to the Office of State Review. After that would be an appeal to a federal district court. So that's how that goes. Okay, and now I'm going to throw it back over to Justin to discuss different types of relief.
Thanks, Steve. So when we talk about relief, we're talking about what do you want, why are you bringing this due process complaint in the first place? What do you want the hearing officer to tell the school district to do for your child in so many words? There's a broad range of relief that can be requested. Hearing officers under the IDEA have fairly broad equitable powers to order what is necessary for the child. So this can include anything from, more if the student is in public school and you just want to increase their services, for instance, speech or OT, you can bring a due process complaint you can request that through a due process complaint. If you want to change their placement from possibly maybe a 12-to-1 to a more restrictive setting or to a less restrictive setting like an ICT classroom, you can do that. You can address transportation through a due process complaint. Funding for outside services. We deal with a lot of situations where a parent wants something like a reading specialist or something to come in and work with the student that the school doesn't have. So there would be funding for that outside reading specialist. But what we wanted to do with this presentation is focus on some of the more common forms of relief. So the first one we're going to talk about is an independent educational evaluation, or what's called an IE, what's known as an IEE. And we're starting with evaluations because I think it's really, they're very important in one, understanding your child's needs and providing a roadmap for maybe what you're seeking otherwise through your due process complaint, or even in future years for your child. You know, as educational lawyers, Steve and I do this every day, but we're not psychologists, and we don't necessarily, we can't make recommendations as in terms of a proper placement for a student. That's really for a psychologist to do. So that's where the evaluation comes in. Now, as I mentioned before, the school district does have an obligation to evaluate the child, but it doesn't, and their obligation is, it's a high standard. They're required to evaluate the student thoroughly in all areas of suspected disability. So this may just be, for some students, their cognitive and academic functioning. But if the student is evidencing issues with speech, for instance, the district would also have a duty to evaluate them for speech language services. If it's motor skills they're struggling with, there might be a duty to evaluate the student for occupational or physical therapy. So the duty is, it's quite broad. Now, whether the school district will evaluate the student, but that's not where it necessarily ends. Under the law, you have a right to disagree with that evaluation and request funding for an independent evaluation. Now, the reason why you might do that is because possibly the school district's evaluation might not be thorough enough. Typically, DOE evaluations, they don't do things like diagnose the child. They don't provide recommendations. They're often very hard to understand and not really explained very well. So you might want a more thorough neuropsychological evaluation, for instance. So what you can do is you can disagree and communicate that disagreement to the school district and ask them to fund a independent educational evaluation. Now, how they respond will vary, but under the law, they are required to either comply with your request and fund the evaluation, or defend their evaluation via a due process complaint. The latter is not something they do very often. Sometimes they will try to work out your request, you know, through resolution, or through by providing an assessment authorization form, setting forth their approved rate for evaluations, and providing a list of evaluators that supposedly accept that rate. Or they might not respond to your request at all, in which case you could seek funding for an independent educational evaluation through a due process complaint. We do fairly frequently, we seek funding for an independent educational evaluation as the sole relief. We keep the hearing, the due process complaint very narrow. It's a fairly quick, it results in a fairly quick hearing once we actually get a hearing officer appointed. That's sort of the first step for that student then in getting the evaluation, figuring out their needs. Other times we seek it as a form of interim relief, or sort of preliminary relief, where we're seeking funding for an IEE, but then we're seeking other things that we'll get into, like maybe private school tuition or compensatory education. So there are various ways you can go about this, but it is an important aspect of the law, and we think it's a very important thing for parents to be aware of. So with that, I'll turn it back over to Steve. He's going to talk about another form of interim relief in the form of pendency.
Thanks, Justin. Yeah, so pendency, also known as the stay put provision of law, might be the most common form of interim relief. The idea is when you're challenging the Department of Education, right, you're saying, we have a disagreement here. The Department of Education says my child needs this. I think my child needs that. Well, what happens while the proceedings are proceeding, right? I mean, it takes some time to get a decision. You have to have a hearing, you have to prepare for the hearing, all of that. So the idea is in the law that you're supposed to maintain the status quo, right? You want to try and keep the child in the last agreed upon program and placement. Now, what does that mean? Well, it could be, for instance, that the Department of Education and you agreed that your child should be in an ICT classroom with 2 sessions of speech per week, right? And then they have an IEP meeting at some point and they say, okay, well, you know what? We think your child actually now should be removed from the ICT class setting and put into a 12-to-1 class with students with disabilities, and we're going to remove the speech therapy. And you might say, wait a second, I disagree. I think my child continues to require that speech therapy, continues to require placement in an ICT classroom. So you file your due process complaint, you ask for whatever it is that you want to ask for as a form of substantive final relief. But in the meantime, you say, while this is proceeding, while we're waiting for this to happen, I want my child to maintain the status quo. I don't want to be pulling my child out of somewhere that might be inappropriate. So we're going to keep the child at the ICT classroom, continuing to get the speech therapy until the proceeding ends. That is the basic idea of pendency. Now, the last thing I want to say about it, and there's plenty more, I can do a whole hour on pendency very, very easily, but the last very quick thing I want to say about it is that sometimes you might put your child in a private school, let's say, for a particular school year. Let's say you challenge the DOE for the 21-22 school year, said, you're not providing an appropriate program. I need to place my child in this particular private school that is designed for students with disabilities. You go to hearing during the 21-22 school year, hearing officer agrees with you, you win. They say the district has to fund the tuition at that private school, right? Okay, now for the 22-23 school year, what happens? The Department of Education winds up recommending the same program or some other program that you don't believe is appropriate. So you file another due process complaint. Well, when you file a due process complaint for the 22-23 school year, you're going to have pendency again. You're going to have pendency. You're going to say, okay, well, while we're figuring this out, the hearing officer just said that school ABC is appropriate for my child. And until another hearing officer says otherwise, I'm entitled to tuition funding at ABC. And that's what it is. So it's not going to mean that you're entitled to tuition for the entire school year necessarily, but you are entitled to it until there is a finding otherwise, right? So pendency is incredibly powerful in that way, all right? So there's a lot more to say about it, but again, we don't have that much time, so we want to move over to some other forms of relief. And one of the big ticket items, which people are always asking about, is how do we get private school tuition funded? Justin, please tell them.
Thanks, Steve. We're going to talk about, so there's sort of 2 main avenues for obtaining funding for private school tuition. The first is actually outside of the due process complaint, the impartial hearing system, for the most part. And that is what's known as a CPST deferral. This is the CPST is a department within the New York City Department of Education. And as CPST stands for, I believe, Central Based Support Team. And what happens is if an IEP team determines that the student's needs cannot be met within the public school system, they can provide that student with what's called a CPST deferral, where they defer the student's school placement to the CPST for placement in a state-approved non-public school. Now, state-approved non-public schools, there's a bunch of them. They're all listed on the New York State Department of Education's website. They vary in terms of the type of school. They're special education schools, but they serve different types of students. Once a case is deferred to the CPST, a case manager from the CPST then works with the parent to find an appropriate private school placement for the child, state-approved private school placement. They're not always successful. There's plenty of situations where students' cases defer to the CPST and they just can't find an appropriate spot. Maybe there's just not an appropriate school out there. Maybe the appropriate schools just don't have seats available for the student. That's fairly common. If they do find an appropriate placement for the child, though, the DOE then funds that student's placement directly, and you don't, at least for private school tuition funding, you don't need to go through the impartial hearing system. However, if you cannot obtain a CPST deferral, or if you determine that a non-state approved special education private school is more appropriate for your child, you can do what's called a unilateral placement. And a unilateral placement is when you disagree with the proposed IEP or school placement for the student, and take the student out of the public school system yourself and put them in a special education private school and seek tuition funding from the DOE. There are certain procedural requirements for this. Most notably is the 10-day notice. You have to provide the school district with 10 days notice that you have issues with the special education program or placement that they have recommended for the student, and that you intend to enroll them in a special education private school if those issues are not corrected or addressed. Typically, I mean, sometimes cases settle, but typically you then need to file a due process complaint seeking funding for the special education private school. Now, there's two types of placements. There's what's called a Connors placement, where the parent is paying either nothing upfront and asking the DOE to fund the tuition to the special education private school directly to the school, or they might pay partial tuition and ask the school district to fund the remainder of the tuition directly to the school. Connors there is a need-based aspect to it. I can't give you an income level or a definite income level that you need to be under in order to qualify for that. That really is a school by school thing that you would need to talk to the school about to determine. The other type of placement is called a Carter placement, and that is where the parent funds the tuition, pays for the private school tuition upfront, and then seeks reimbursement from the DOE. Now, these cases are analyzed when they go to hearing. They're analyzed under what's called the Burlington-Carter framework, named after Supreme Court cases addressing these issues, and it's a three-pronged test, and you will hear this come up if you are involved in these impartial hearings. The first prong is the school district's burden to show that they offered the student a free, appropriate public education for the school year in question. The second prong, it is the parent's burden. So if the school district does not meet its burden that it offered the student of faith, then you go to the second prong. And that's the parent's burden to show that the private school is appropriate for the student, meaning that it offers special education and related services tailored to meet the student's needs. It doesn't have to be perfect, but it has to be somewhat individualized, and there's, the parents make a showing typically by calling witnesses from the school to testify about the program offered for the child. And then the third is there's an equitable aspect to this, where the hearing officer will consider whether the parent did anything to prevent the DOE or the school district from doing its job, whether the parent cooperated, attended the IEP meetings, provided the requisite notices, that sort of thing. Finally, there are other ways to get tuition funding to a special education private school that are kind of be a little bit beyond the scope of our presentation, and get pretty, it requires some creativity on the part of the folks drafting the due process complaint. Steve will get into one aspect of, or one avenue for that next. But these are the two sort of primary ways we look at private school tuition funding. So with that, I'll turn it back over to Steve for Comp Ed.
Thank you, Justin. So compensatory services, they are more backward-looking services, right? Whereas Justin was just talking about getting a private school funding, or talking about previously the independent educational evaluation, the Ieee, right? That's to say, there is an issue right now that I need addressed. I need this relief. I need to, for the current school year, I'm not happy with this placement. I'm going to place my child in a private school and seek funding, right? It's forward-looking. It's addressing an issue right away. But sometimes we have to address issues from the past. So sometimes we'll have clients that'll come to us and, they say, things have just not worked well at the school. What do I do? I want to put my kid in a private school. I say, okay, well, maybe a private school is appropriate. Let's figure it out first. And that's why we might want to get an independent educational evaluation first. Let's get a comprehensive neuropsychological evaluation, potentially other evaluations, to help us understand what it is that your child actually needs, right? And so once you get that evaluation, you might realize, oh, wow, this child really has not been getting what they needed for a substantial period of time. And so we need to compensate them for that, right? Maybe school ABC is going to be appropriate for the next school year. When we look at 2022, 2023, you want to place your child in school ABC, that school is going to help meet the child's needs going forward. But it's not intended and won't make up for 2 years of an inappropriate program from the past, perhaps, right? So what will? Well, there's broad equitable power here for the hearing officer to determine what level of services is going to get the child to where they need to be. There's two different types of kind of ways we look at compensatory services. There is a qualitative approach and a quantitative approach. A quantitative approach is talking about quantity. It's talking about, like, okay, the child was supposed to receive an hour of speech therapy per week for 1 year, and they didn't. So let's multiply the amount of weeks that they missed the speech therapy and say that's the compensatory amount of speech therapy. Another thing is still within the kind of quantitative approach. You could say, well, the student was mandated to receive 1 hour of speech therapy, but in reality, they should have received 2 hours of speech therapy. So let's use that 2 hours times the amount of weeks, right? That's a quantitative type of way of doing it. Qualitatively is more looking and not as much concerned about what was missed, but what is needed to get the child to where they would have been had they been provided with the appropriate amount and type of services in the first instance. That's what the idea of the qualitative approach is. And that's typically what we have been dealing with for the most part in the New York City impartial hearing system. Most impartial hearing officers have been kind of going that route for the most part. And so we get testimony from evaluators who will say, well, this kid is 2 years behind grade level in math and reading. And had they been provided with an appropriate program, they had the capacity and should have been at grade level. And based on my professional experience, I think they will require X amount of hours of multisensory tutoring to get them to the point they otherwise would have been had they been provided with something appropriate in the first instance, right? So that is the typical way of going about seeking compensatory services. You can get a variety of different types of services. You could get tutoring executive function coaching, you could get applied behavior analysis or ABA, speech, occupational, physical therapies, counseling. There's really no specific limit. You just have to make your case. Another thing is parents sometimes come to us and they're like, we paid, $100 an hour for speech therapy per week and $200 per hour, $200 a week for tutoring for the last 2 years because we've been trying to help our child get what they need. Well, that's another thing you can seek. That's a kind of form of compensatory services to say the parents never would have incurred those costs, but for the fact that the Department of Education failed to provide them what they needed. If the department gave them an appropriate program in the first instance, the parents wouldn't have had to pay that $100 in speech therapy per week or $200 of tutoring per week, right? So sometimes it's a mixed bag. We can seek reimbursement for the out-of-cost expenses and say, but still those out-of-pocket expenses weren't sufficient to get them to where they need, and we still need additional prospective funding and prospective services. So that's something to consider. And that also goes with the independent educational evaluations. Sometimes we get the Ieee, the parent comes to us and they said, I just paid $7,000 for a neuropsychological evaluation. Yes, they cost that much. Some cost even more than that. Some are a little less, but that's within the range. And they paid $7,000. Oh, well, we can get that reimbursed possibly, right? Because the district might not have provided the parents with the knowledge of how to seek an Ieee. And maybe it's the case that, the parents never would have incurred that cost, but for the fact that the district failed to thoroughly assess in all areas of suspected disability or to have done so within the, requisite time frame that they're supposed to do. So those are all things to consider. Last thing for comm services, just to show a example of how broad the equitable powers of a hearing officer are. This is very rare, but we have had a couple cases in which we have gotten an impartial hearing officer to order private school tuition for a subsequent year in order to compensate for past deprivation of FAPE, right? So in one case, we even got like over a year, almost 2 years. Like in the middle of a year, the hearing officer said, we're going to order that the district has to fund this private school tuition for the remainder of this year to compensate for the past, and they have to pay for another year of tuition to compensate for the past. So that's unusual, but it is possible. All right, so I see we have a fair amount of questions. We're not going to be able to answer all of them, like I said. If you're throwing them in the chat, try and throw them in the Q&A section. I think it's easier for us to just work off of that. Justin's going to start it off, and then I'll chime in.
Yeah, so a lot of good questions. The first question that's up, and I think this kind of relates to another question that I see in the chat, is could I file for an impartial hearing without a lawyer? Why or why not? The answer to that is yes, you can. You don't need a lawyer to participate in the system. I believe there are resources as to how to do that on Include NYC's website. There's also this school district is required to provide parents with a copy of their procedural due process rights each year. Those are a little tough to wade through. But that should also provide some guidance. And there's also, I think you can look around on school districts' websites for the most part and figure out how to file an impartial hearing request depending on your school district. Relatedly, there's a question about money for legal services for this type of lawsuit. And so it's a little more complicated. It's a bit complex, but essentially the law entitles parents to reasonable attorney fees if they're the prevailing party at an impartial hearing. So if you win on some or all of your claims in your due process complaint, you are entitled to reasonable attorney's fees. How this works in practice is typically the attorneys themselves. You provide the attorneys with consent to do so, and the attorneys themselves kind of pursue their fees from the school district. But this results in a system where it's much more. It varies by firm, but it is more affordable to obtain an attorney to represent you in a special education matter than in some other areas of the law where there is no similar fee shifting provision. And I will say there are also a lot of great organizations that provide free legal services for individuals under a certain income level. And I think we have resources on our website, and include NYC also has, can direct you to some of those organizations as well.
All right. Yeah, thanks, Justin. That's a good answer to that. I think I'll take this next question. Is I have asked for an IE twice now, and I keep getting a refusal via a PWN or a prior written notice, which is not what the law states. Well, anonymous attendee, you are correct. That is not what the law states. What are your options? Look, if you ask for an IEE and they fail to respond in one of two ways, which is they either have to agree to give you the IEE, or they have to file a due process complaint on their own to try and challenge, to try and defend the evaluation that you're challenging, or to show what you're asking for is unreasonably expensive or doesn't meet their criteria. So I don't know the details of this question about like what specifically you're asking, but the idea is you should be challenging an evaluation. Like the DOE had to have done an evaluation. And if they did an evaluation, you can challenge it. Now, you can't just like challenge an occupational therapy evaluation and say, I want a neuropsychological evaluation because I disagree with an occupational therapy evaluation. Those don't kind of jive, right? It has to be of a similar kind. And the law behind IE, it's a little bit more complicated, right? We're simplifying some things. There's more details and subtleties. That being said, if they refuse to offer you the IE, you can file a due process complaint and you should win. I mean, it's like a matter of law. It's very, very clear. I had one hearing last week, I think it was, on an IEE case only. It literally lasted less than 10 minutes. I explained, this is the law. The DOE didn't respond in the way that they're supposed to. I'm not calling any witnesses. I don't have to. There's no dispute as to any material fact. She said, you're absolutely right, and issued the decision that day, giving the full relief sought. So not all hearing officers are going to work that quickly, but it's straightforward. And the district representative didn't really fight it at the hearing because there's nothing to talk about. It's a matter of law. So again, reach out to an attorney if you're not sure what to do with that, but that's time for an impartial hearing request, I think.
I'm gonna skip down a few because I just think this is a great question. How far can you go back for compensatory services? We run into this issue a lot, and it's I think I was
gonna call dibs on that. I was gonna call dibs, and I went with the IE one. But okay.
Yeah, so the IDEA has a 2-year statute of limitations, which means that a parent has 2 years from the date they knew or should have known of their claims to file a due process complaint. Now that has become actually a little murky because the statute of limitations was told during COVID by the governor for it was about like 241 days. So that has extended the statute depending on when your claim came about. But it's generally 2 years. However, the knew or should have known of the claims, that is really a question of fact, and can get, I mean, it's the topic of much dispute between us and the school districts fairly frequently. We file due process complaints sometimes that go back many school years, and the basis for that is among other things, that maybe the parent didn't know about the student's disability until more recently. Maybe it took them until they got a neuropsychological evaluation to really understand the claims that they had and the injury that has occurred to the student as a result of the DOE's failure to provide appropriate services. So the answer is generally 2 years, sometimes 2 years and 241 days, but a lot of times there are arguments for going much further back than that.
Yeah, thanks, Justin. I mean, just to piggyback slightly, because he did steal the fun question, I think there's a lot there to unpack. It's also about individual claims. So I will say that oftentimes, and I disagree with this, when some hearing officers, and the way the district a lot of times will do it is like, oh, any claims 2 years before this date is necessarily barred by the statute of limitations. It's the individual claims. So like Justin said, you might get a neuropsychological evaluation that gives you new information. You might realize for the first time that your student has autism. Well, how could you have claims, before that? You wouldn't be aware of your claims. So there might be some claims that you were aware of. You might have known that they weren't getting their speech therapy, and maybe that's something you could have brought up previously, but there's certain claims you wouldn't have been aware of. So it's an interesting topic. I did want to mention, somebody's been asking about pendency, or there's a couple questions about pendency. First is the pendency similar to the stay put provision? It is, they are identical. It's the same thing. Pendency is just another form of saying the stay put provision, and it's to maintain the status quo. Someone else, or maybe the same person, said, in regards to pendency, is a pendency order from an IHO judge still required for pendency to take effect? Not exactly. First of all, I mean, it's supposed to be an automatic right. There's the way things are supposed to be and the way things actually are. So because of delays and everything, there's been agreements now. Like the New York City Department of Education oftentimes will agree on very clear cases. They'll agree and they'll say, yes, we're in agreement and we're going to fund this and we don't have to get an impartial hearing officer involved. Other times you do need to get an impartial hearing officer involved. So it's not absolutely necessary to get that order, but sometimes you do need to if there's a dispute as to what it is.
Thanks, Steve. So this is skipping down a few again, but this caught my eye and was relevant to something I spoke about. The question was, what would you say about an education attorney who recommended a neuropsych and did not advise family to seek reimbursement? So that's a little tough to say without some more detail, but concerning the situation. But that it's certainly. It's certainly understandable, and I can understand situations where that would be an appropriate, the appropriate advice. If there's a time component, oftentimes, I mean, we've done this where we advise parents to go ahead, pay for the independent neuropsych evaluation or another independent evaluation out of pocket. Just because we need to know the results, because there are other things at stake here. Maybe there's a sort of rush to get the child into a private school. Maybe there's a super urgent need for compensatory services or tutoring or something. So there are certainly situations where that could be perfectly understandable advice. There is a possibility of, if you don't go through the process of disagreeing with an evaluation and waiting for the DOE to respond, there is still a possibility of requesting reimbursement for the evaluation in the due process complaint on other grounds. That's certainly a thing we do fairly frequently, but it's really, you know, it's a case by case thing.
Right, and just to piggyback off of that, you know, again, there's so many individual facts. We're not going to opine about whether or not an attorney handled something properly, because we don't know their circumstances. We don't know what it is. So, you know, it could be possible, right? We personally like to explain to our clients what's going to happen. And like, if you pay out of pocket, like you might not, first of all, we can never guarantee you're going to get reimbursed. There's ways to strengthen the ability to get reimbursed. And sometimes we'll say, you know, it's more time sensitive and you need to do this way, in a way that's less likely to get reimbursed, but that's the only way you're going to be able to get what you need, and to get the ball rolling to do things like get the appropriate program for the next school year. So it really does depend. I see a question about what can I do if my pre-K child who has an IEP for speech therapy and he's not received any of the services since the school started in September. I mean, that is a pretty clear case of compensatory relief, right? Like that's something you definitely should be able to get compensatory services for. If they're basically saying in an IEP, your child needs speech services, and then they're not actually providing it. You can first contact them and say, can you do something? I want this. How are you going to compensate for this? The school might help you out there. They might actually come up with some way. There's sometimes they give these things called related service authorizations, and you might be able to try and find a provider that can do it. Sometimes you can't find a provider on the list that they give or at the rate that they do, and then you might have to, you know, do the impartial hearing process. That's typically what it is. I would also reach out to include NYC about this type of thing first, possibly, because there's some, they have some resources about that. I think there's also there's some other things going on because of the pandemic, and somebody else asked something about that. How successful have attorneys been in getting comp services since the pandemic? Would families be able to file a 10-day notice, parentally placed, or for related services? You don't necessarily need to do a 10-day notice for seeking related services. It's a little bit more complicated. Maybe it might be a good idea to do if you're going to be putting them on notice that you're going to start the services on your own. It could help, but it's a little bit more nuanced than that. So there's comp services, and then there's other forms of relief that are being provided by the school district through this other service, recovery services and whatnot, which I don't have quite as much information on, to be honest, though I know Include NYC has some resources on that. But Justin, I don't know if you want to chime in on any of that or just go to another question. I will say, we only have about a minute left. So Justin can opine on that and maybe take one more question. And, you know, I'm sorry, we can't get to everything. You have our email addresses. We're happy to address later on. Go ahead, Justin.
Yeah, I'll try to shoot on two quick. There are a couple questions in here about timing and how long this process takes. And, you know, I think Steve has alluded to this, under the law, it should be, correct me if I'm wrong, Steve, 75 days from filing of the due process complaint to the resolution?
The decision, I think it's 90 days, I think.
90 days? Yeah. You know, it's designed to be a quick system. And I think in a lot of places outside New York City, it does operate that way. Unfortunately, in New York City, it does not always operate that way. In fact, it typically doesn't operate that way. And there are a lot of factors that contribute to delays, even to get a hearing officer appointed. But even once a hearing officer is appointed, there are delays involved. So it's hard to give an average time. But you know, there is some degree of patience that's needed through this process, because it can be a somewhat lengthy process. Last question that popped up. If you get a winning decision for a private school, does your child get to stay there for the rest of their educational career? No, unfortunately, the way the law is designed, it's a year-by-year system. You will have pendency at that school going forward, but the DOE essentially gets gets a shot every, I mean, they have to create an IEP for the student every year. And the way the system is designed is whether that's appropriate is kind of reassessed each year. So it's not an automatic that you would remain at the private school for the rest of the educational career, and likely you would need to file due process complaints every year to get funding.
Thanks, Justin. I mean, we're like a minute off over, include NYC is going to come down on us hard here, right, Robert? So I don't.
Overtime.
Absolutely not.
We got time for this.
We really appreciate all the information you provided for everybody. I just want to reiterate, our helpline is happy to help answer questions and direct you to the appropriate resources. And again, I just want to thank Justin and Steve for all the information they provided today.